With respect to item number 9 and 10. Item number 9 and 10, these are the two appeals by the income tax department. Maybe this may be taken up some other data.
Why?
So I could not go to because I was out of station. I reached Guwahati like late night. I could not go through the files.
After summer vacation.
Lots, 9 and 10. Much.
Please, Your Lordship. With the consent of the other side, I'd like to mention item number 15.
1-5.
1-5, Lordship.
Yeah.
Mention will be posted after vacation, Lordship.
Who is for the petitioner?
I'm for the petition, Lordship. That may be fixed, maybe after.
After summer vacation, I mean.
Obliged.
Please, Your Lordship, with the consent from the other side, I beg to mention item number 11.
Yeah.
11, Lordship.
Lordship, I'm appearing for item number 11, appellant side.
Therefore, the appellant,
I'm
Lordship.
for the appellant, Your Lordship.
Yeah. After summer vacation.
Obliged.
May it please your lordship, I beg to mention item 8 on behalf of council for the petitioner lordship. The council has some personal difficulty today. Lordship may fix a date after vacation.
8.
8.
Urgent.
May praise the Lordship. Lordship, with the consent of the other side, I beg to mention item number 16, Lordship. I'm appearing for the sole respondent. Lordship, we need some instructions in the matter. I'm praying for an accommodation for 3 weeks, Lordship.
Urgent.
Obliged, Lordship.
May I please, May I please, Lordship, I have like to mention listing of the case. I read this one, my lord, what happened is petitioner's residential flat was put in the mortgage and surface X, it was already, my lord, auction sale has been done. Petitioner earlier has offered 45 lakhs. They said it is low. Now in 52 lakhs it was sold. So to save this flat, so there should be one direction that my representative should be considered that I can pay the 52 lakhs, then I will save my residential flat.
Representation business, where is the question of representation? If they move that representation, then consider it. Where is the question of giving direction by us?
No, direct my lord, just only one thing. Otherwise,
You
tomorrow,
are
day
free
after
to
tomorrow, will be nowhere, my lord.
Basic matters, you know.
I know, my lord.
Least preference.
I'm not doing that, but some manamas, if possible, I try my luck, my lord. Tomorrow, you know, I file this. Only at last resource.
May I please, the Lordship? Lord, I beg to mention a pending writ appeal for hearing, my Lord. Lord, it was listed long back, next week, any date, my Lord. Some urgency,
Next week,
my Lord.
next to next week.
My Lord.
Hey,
Obliged.
please your lordship, I pray for listing of an writ appeal, lordship, on 13th of June, my lord. I have filed it on 7th June. And yesterday, lordship, one connected matter was also there, and lordship has directed to list this matter along with this matter which was filed by me. Obliged.
May it pleases you, Lordship. Your Lordship, adjournment slip has already been submitted, Your Lordship, pertaining to item 18 to 23. I have taken consent of the other side, Your Lordship. Kindly matter may list after vacation, Your Lordship.
Urgent.
Deeply
May
obliged.
praise the Lordship. Lordship, as regards item number 24, Lordship, we have filed an affidavit in opposition yesterday. Lordship, that may be called for, Lordship. Obliged, Lordship.
Daily list for admission item 1.
Lordship, please. For your lordship's consideration, I have got a chart made in order to divide and measure
How
jobs.
much land was allotted total?
Yes,
Total land.
yes, I have got that chart. Your lordship says I put up a query as to what is the bigha and the area which was given to us, which is 2542. Does it include the entire plot?
Yes.
We have done that calculation in terms of the chart that is available in the revenue authority. It looks like the land that has been given is actually 1 bigha 4 kotha 12 lechas. In terms of 25.69.
That is total land.
Yes, and we have given the calculation of both the DAG numbers 1919 and 1920. So the calculation is 1 bigha is equal to 13.38, which is on the next page is mentioned.
25 into 42 array.
Yes, is
That is
actually one
equivalent
bigha,
to-
4 kothas.
That is equivalent to
One
big-
bigha, 4 kothas, 10 lesas. In terms of the chart which is annexed at the second page. And your lordship should see at the bottom, at the last one, it says 5 bighas is 13.38, the last one. So that's 1 bigha, 13.38. I've also mentioned it in the first slip. And then comes 4 kotha, is 10.07. It's on the first row.
So you mean to say that
The entire land, in fact, slightly
entire land.
more.
notice. So and so. Yes, you are appearing for,
My lord, 5, 6, 7, and 8.
what about the others?
Others, my lord, are standing counsel for revenue department. May I accept? Revenue.
This state of Assam Commissioner and Secretary, Joint Secretary, and again Joint Secretary. Revenue and
Miss N. Bottle
My
for
lord.
1 to 4.
Yes.
You're appearing for 1 to 4. And
So
5
why
to
is Joint Secretary Revenue and this Disaster Management Land Reform Branch is another secretary? Joint Secretary 3 and 4.
One
seems
is-
to be common.
Settlement bank.
One is settlement branch, your lordship. The other is land reform branch. They are two different.
Different branches.
Yes.
You are appearing for
For the revenue department,
Revenue
1 to 4.
One.
all the
Yeah,
12 sections.
Miss, so-and-so is appearing on behalf of the respondent number. So-and-so is directed to accept notice on behalf of the respondent number 1 to 4. And Mr. So-and-so is directed to accept notice on behalf of respondent number 6, 7,
5, 6, 7, and 8.
5, 6, 7, and 8. It's stop. They may file their response to the writ petition. And what about 9? 9, 10.
That's the Santha private notice. That notice has to go.
Notice,
Private
my lord.
response.
Notice will have to go. Private
9
respondents.
to 15 by register.
9 to 11,
9 to 12. 9 to 12.
Issued the respondent number 9 to
9 to 15.
9 to 15.
15, your lordship.
through registered daily returnable on when
Anytime convenient to your lordship, after vacation, anytime.
returnable just after opening of the
4
summer
weeks.
vacation.
Grateful,
Returnable on phone.
grateful. 18.
Item number 2,
So this matter pertains to entitlement of pension to the first wife. And that,
What happened on the
Yes,
last
my lord.
occasion? You said.
My lord, last-
we
yes.
will do the calculation.
Yes, yesterday we have received clarification from the department, agriculture department. And yesterday itself, we have issued the authority letter to treasury officer and copies to copy. Already issued authority. As a trustee, say, Bulumai Mohanto, his appellant will act as a trustee and he will distribute accordingly. As per Juniper BV's case, my lord.
And what about the share of that?
That will be, that trustee will give. Share will be, they had not decided if they will give, suppose here Juniper BV's case is saying Miller full base, full court judgment of this our honorable court. Trustee will allot, if any grievances, and then they will decide among themselves for others, from law, court of law, they have to come. That is the solution. Because trustee will do it. Lordship, here is clearly incident. And instruction also from judicial department has come to agriculture department. Intern agriculture department has written to us, the same trustee, it is to be given trustee. And if you go by full bench judgment of our honorable court, that is, my lord, Junupa Bibi's case, my lord, reported in 2023 one GLT. Para 22 is saying that
19, no, 19. No, para 19.
22. Main effective para 22.
Appellant is the second. Appellant is the second wife.
First wife.
She is a first wife and the children of second wife.
Citation is invalid.
2023
2023. Copy is already there.
742,
Copy is already there.
paragraph 22.
Yes.
Counsel, what are the directions by the learned single judge?
Learned single judge was pleased to pass an order on the basis of same
Para 30.
para.
30. Para 13 of the improved order.
My lord, my lord.
76.
Upon due partial of the judgment of the full court in this, Mr. Junupa Bibi by the apex court and the Ramashri Devi read with amendment brought to the rules 143, the court is of the view that the matter requires a decision of the authority concerned as to the claims made by the present petitioner, the claims as per number 8. The authorities will decide the claims of the petitioner, and if the claims of the petitioner are found to be genuine upon necessary verification, there then the same can be released in respect of the dependent unmarried daughter as per law laid down by full court judgment of, that is Junupa Bibi's case, by the apex court in Rameshwari Devi's case following the procedure laid down 143, rules 169, and Assam Council of 1960 amended.
There is a specific direction to release
By the authorities, but no. That is why, my lord, we
in
have.
respect of the dependent unmarried daughter.
Yes.
And by this letter, you simply said she is the trustee of that. What is this?
No,
Why?
here that is why clarification was sought from the agriculture department, my lord. That is why this information, I am appearing on behalf of accountant general. Whatever information, clarification from them, there,
Who is going to decide this share of that unmarried daughter?
that will be decided by the concerned department.
What concern
If
department
at
is
all.
doing? Then where is the question of this, by issuing this letter, what you have done?
Next page, your lordship, agriculture department's letter.
One of the full bench judgments passed in rendered in the case of Junupa Bibi.
That's what I was thinking, because it's not a sharing property. Yeah. That is good.
It is for me appropriate.
To AUPR as well. Yeah, remedy there would be to make a claim from within the appropriate forum. There will be there to make a claim.
Will be order of the. Except the special. Will be order, except the special.
So, yeah, what do you, what the full bench judgment said?
Well, a full bench judgment is very clear. If I may take on lordship to paragraph 19 onwards.
Where is that judgment?
Well, it is there in the record, my lord, 2023 1 GLT 736, page, my lord, 6, my lord.
6.
Yes, my lord. Paragraph 19. A conjoint reading of note 1 to rule 143 to
Just
22 to 2 years.
page 6 of the appeal.
no, my lord. It is there in I have submitted separately, my lord, the judgments. It's 2023 1 GLT 736. Copy there, copy.
Relegation point, I hope, 22, relevant pen 22, 23.
Well, paragraph 19. A conjoint reading of note 1 to rule 143. Paragraph 19, my lord. A conjoint reading of note 1. Page, my lord, here, page 6, my lord. Page number may not tell you, my lord. with the
Yes.
book. All right, conjoint reading of note 1 to rule 143.2 and rule 143.3 of the pension rules of 1969 makes it explicit and unambiguous that the family pension will be payable to the eldest of the surviving widow in the event of there being 2 or more widows, and further that even if there are minor children who may also be entitled to the benefits of the family pension, the pension would be paid to the only one member of the family at the same time. Where at first instance, it would be paid to the eldest of the surviving widow and thereafter on her death to the next surviving widow, if any, and in its absence to the minor children. Next paragraph. As a corollary to the provisions of Rule 143.3 of the Provision Pension Rules of 1969, Note 1 to Rule 143.2 would have to be read to mean that the family pension would be payable to the eldest of the surviving widows in the event there are 2 or more widows, and thereafter on her death, it would be payable to the next surviving widow, if any, and thereafter to the minor children if the occasion arises.
We understood that, the
And
pension at the first instance will be payable to the.
my lord,
first wife.
next is very important.
Yes.
Paragraph 23, my lord.
20?
22 and 23. We get 22, 23.
22 and 23.
Yeah.
We further hold that the family pension being payable to the eldest of the surviving widow or wife would not mean that the entire family pension so payable would be the personal property of the eldest of the surviving widow or wife, and the family pension so payable would be held by the eldest of the surviving widow or wife as a trustee for all such other persons who are entitled to the benefits of the family pensions in terms of Rule 143 of the Pension Rule 1969. Next, my lord. We also provide that in the event any such other persons who are entitled to the benefits of the family pension in terms of Rule 143 of the Pension Rules of 1969, including the second or further wife, in a case where the parties are governed by the Mohammedan law, are not appropriately maintained by the eldest of the surviving widow or wife to whom the pension would be paid, the remedy thereof would be to make a claim for maintenance in the appropriate forum under the law, and not a claim for a payment of the family pension by the state authorities directly to such persons, my lord. This was the finding, my lord. But they cannot make a claim directly to the state authorities for payment of pension.
The point बाकी देखो दिया पेंशन के लिए निष्कासन नियम दी
Acha, Mr. Biswas, Mr. Barua and Madam Boda. See, family pension is ordinarily meant for the benefit of the family of the deceased. Once pension is paid, it is believed that the entire family will be taken care of with that pension. But that is true in case of those families where there is no clash of interest amongst the members of the family who come within the definition of family. What happens when the interest of the widow turns out to be in any way adverse to interest of one of the members of the family? Can this judgment apply in that case?
That's what, my lord. In my case, there is no dispute. The writ petition was filed well before the family pension was awarded in my favor, my lord. The family pension is pending since 2013. They made a claim, my lord, in the year 2021 by a writ petition when I was not receiving family pension. My lord, that writ petition was premature. Well, why I'm saying
You are going
because
somewhere else, Mr.
my
Biswas.
lord, there is no clash. My lord, I have admitted in my stay vacating petition that I am ready to part a share of my pension with the child of the second wife.
What is the share?
My lord, share, my lord, till.
You give a commitment on that, we'll close the matter.
What is the share?
Yes, my
If
lord.
there is no clash, you do it.
But there is no clash. I have admitted in my petition.
You say.
You have admitted, but what is the share
My
ultimately?
lord, share until and unless I know about the quantum of pension I would be receiving, my lord, it is, my lord.
We can't, if another, if you are not taking care of the other members
Lord,
of
I
the
am taking
family,
care.
and if they are entitled for that.
My lord, they are pursuing higher studies, my lord. They are, my lord, living in a good life, my lord. I am not denying their pension.
We are not saying that you give whole pension to her.
They have their
But
own income also,
ultimately,
my
you
lord.
have to come to a understanding that yes, that much of amount you are going to share with the unmarried daughter of the second wife.
I am committing that, my lord, I would share a part of my pension with the second wife
For
child,
that,
my lord.
we'll ask them, they'll appear and then you come to understanding, then only.
If they are agreed that they will, but that's what the full bench law is, my lord, settled by full bench. And as per
That's right,
pension
but
rule, my lord,
ultimately, the state, in the full bench judgment, they have specifically also made clear that the state is going to decide that, they can decide that.
but my lord, the pension rule doesn't mean that, my lord. The
What?
pension rule says, my lord, two PPOs cannot be issued in favor of, my lord,
You are
two
right,
family
but in
members.
this para number 23 itself,
Yes, my lord.
what the learned.
But if in a given case, the
But
state
however, if
authorities,
in a given case, the state authority.
On their own volition.
Or of the view, the unacceptable authority is agreeable to require to pay separately to any such member of the family.
Yes.
This judgment may not constitute an absolute bar.
yes, a liberty is given to the department. So there was a submission on the part of the department during the read proceeding, my lord, two PPOs cannot be issued as per the pension rule. That's why they have come to a conclusion that the eldest of the surviving wife,
Maybe now you offer what share you are ready to.
as
give
your
to-
lordship suggests, my lord, 30%, 40% of the total pension amount.
Okay. Pursuant to the direction given by this court. The concept of the concept of the accountant general state of Assam has submitted that the senior accounts officer while letter dated 10/6/2024 has already issued a direction to the Treasury Officer, Lakhimpur Treasury, to make necessary arrangement for payment of family pension to the appellant, that is first wife of the deceased employee, comma, as a trustee for the whole family, wide FPPO number, wide to the whole family, full stop. It is stated by the learned counsel for the accountant general that the agriculture department in its letter dated
10-6, Miller,
10-6.
2024.
This is, this second letter is also of 10-6.
Yes, yesterday they have sent and
10-6,
we also sanctioned
2024.
yesterday. That's why both
Has
data
made
same.
it clear that Rule 143 of the Assam Pension Rules 1969. In Rule 43, in bracket Roman 3 of the Assam Pension Rules 1969, there is no mention of sharing the family pension amount or percentage of share of family pension to unmarried daughter of the deceased officer, and therefore no such determination can be made. Full stop. We have taken note of the judgment passed by the full bench of this court in Remufa Bibi appellant versus so and so, so and so, wherein in para number 23, this court, while observing that if any other family member is not appropriately maintained by the eldest of the surviving widow or wife to whom the pension would be paid, the remedy would be to make a claim for maintenance in the appropriate forum under the law and not a claim for payment of family pension by the state authorities directly to such persons. However, the full bench has further observed that if in a given case, the state authorities on their own volition are of the view that under acceptable circumstances, the authorities are agreeable or required to pay pension separately to any member of a family of a deceased employee, comma, this judgment of the full court may not be construed to an absolute bar on such separate payment. Full stop. Taking into consideration the above, we are of the view that the state government can very well decide the
After hearing nonsense.
share of the unmarried daughter after unmarried daughter of the deceased employee after providing opportunity of hearing to the affected persons.
The appellant is also agreeable to.
The however, at this stage, the appellant has submitted that he is ready to give share to the unmarried daughter of the of her husband. Her husband, full stop. In view of the above, let notices be issued to the respondents number. Who are the private respondents?
Yes, my lord. Respondent number 8, my lord.
Respondent number 8, returnable on when after summer vacation, registered AD, so and so. Either you come to an understanding, otherwise we'll pass some order that the state will decide that, and then that share.
My lord, I am ready to share, my lord. That's what I have submitted.
So, have an understanding with the other part.
My lord, my predicament is that my lord, appellant is a 76 years old lady, my lord.
That's
If my lord,
right.
God forbids, my lord, if she dies, my lord, the pension would be hanging in the department only. But it's a question of pension, my lord, the retirement benefits of the deceased husband, my lord.
That's why only.
But
we
if
are
it is
saying,
listed after vacation even, my
That's why
lord.
only, that's why only we are saying, please settle, this, in between you.
My lord,
Try to,
I
try
have
to allow
submitted,
the state government to come into the matter.
my lord, I have submitted before this honorable court that I am ready to part 30 to 40% of the share of the pension, my lord. My lord, that's a fair submission, my lord.
Let's come, then, get the notices served upon the.
Then if your
respondent.
lordship
Then
wants
ask-
me to share 50%, my lord, then also I am ready, my lord. But keeping it pending, my lord, doesn't make, my lord,
That's why
the
only.
party
for
will
that-
suffer, my lord.
For that, we have to hear the other party also.
Hello, it's been, it's the sixth time.
So you mean to say that we pass this order without hearing them? It may be in your benefit.
Well,
She may agree to take 25% of the amount.
Yes,
Then,
but what I'm submitting, my lord, this is the sixth time, my lord, it is.
okay, fine. Same order.
143. 143.
143 Roman, in bracket Roman 3.
An appellant that she is, they did not, she.
Right.
Mr. Biswas, when you appear as a counsel in a court of law, have some grace in understanding what the court is saying.
Sometimes,
You appear to be always very angry about the system.
sometimes we are, my lord, for the clients, my lord, when they are, my lord,
Try
helpless.
to understand what we are conveying. So you mean to say that we pass a order without hearing the other side?
But I'm not saying that, my
You
lord,
are
they
not
should be,
saying
they should be
insisting on
heard. my lord.
this. That is, the matter is pending since then, we understand that. But ultimately, we have to decide the matter. Then for that purpose, we have to issue notice to the other side also.
That's I understand, my lord.
That you understand, then please. Yes, next.
Item 3.
May I please, yes, on previous date, my lord. Standing counsel representing my lord, the principal secretary NC Hills had made a submission that the amount would be paid within 2 months.
Lordship, we have filed our affidavit, Lordship.
What affidavit, whether you have made the payment or not?
Lordship, within 2 months, we will pay the petitioner his amount, Lordship.
Huh?
Lordship, as per our affidavit, Lordship, within 2 months, we will pay the petitioner his balance amount, Lordship.
Now, my lord, defying that order of this court, my lord.
3/6/2024.
Yes, my lord.
That the amount due to the appellant will be paid within a period of 2 months.
Now that defying that order of the honorable court, they filed one affidavit on yesterday, my lord, by the subordinate officer of executive engineer. Whereas he has obtained instruction from principal secretary, respondent to.
Lordship, executive engineer.
He is the authority to provide the. my lord.
So, you mean to say that this affidavit is not acceptable?
My lord, affidavit has been filed, my lord, saying that they will pay.
Filed with the assurance that the payment will be made within 2 months.
This affidavit is not on record today, my lord. They filed it yesterday and copy was served, my lord, evening.
Give us the copy.
I have brought 2 extra copies, my lord.
Executive engineer cannot make the when I wanted to pay, but this, but the option was considered.
This executive engineer is going to clear the bill.
Lordship,
This respondent number 5 is going to clear the bill, or some other authority is going to clear the bill? Who is authorized to clear the bill of this
executive engineer, Lordship.
executive engineer
Lord-
himself?
Lordship.
He is the disbursing authority also.
Lordship,
He cannot say that funds are not available later.
Lordship.
Now, again, at the next time you don't say, "Okay, I have already referred the matter to so and so, and the matter is pending at his end or her end or whatever it may be."
He has to pay even if the fund is not available.
Lordship,
That you are sure.
that,
We'll record it.
Lordship.
Pursuant to the direction given, time given by this court on 3/6/2024, then in concert for the NCL has filed an additional affidavit of the executive engineer PWD My Bank Division District Dima Hasao, who is the respondent number 5 in the present writ appeal. Full stop. In the said affidavit, it is stated by the deponent that the appellant's pending bill shall be cleared within a period of 2 months. Full stop. The affidavit is filed on 10th of June 2024. Stop. Then it concern for the NCL has submitted that the respondent number 5 is the authority to clear the bill, a pending bill of the petitioner, and he is also the authority to disperse the amount due to the appellant. Stop. Taking into consideration the assurance and the taking into consideration the specific statement given by the respondent number 5 in his affidavit filed on 10/6/2024. We list this matter. We dispose of this writ appeal. Full stop. It is made clear that if the pending bills of the pending bill of the appellant is not cleared within a period of 2 months, as stated in the affidavit filed by the respondent number 5, he shall be free to avail appropriate remedy available to him under the law. With these observations, this writ appeal is disposed of.
Otherwise, my lord, the respondent three is the additional civil engineer. He used to, this respondent three is the additional civil.
Just a minute. Stand to the filing the authority of with the direct that the payment of the is on the 10th of August. That's it. We will directly and we will act in accordance with the instructions. Taking note of that. Including the care of. Also, the authority disburse the amount which the appellant. Taking into consideration specific statement given by the file, in the file on campus
We are of the opinion no further order is required to be passed in this writ appeal. However, it is made clear that the authorities of the NC Hill Corporation or Autonomous Council are bound by the statement given by the respondent number 5 in the writ appeal, in this affidavit. No further order is required to be passed. However, the authorities shall take appropriate steps for clearing the pending bill of the plant by 11th of August 2024. नहीं ये हटा दो, ये हटा दें। अभी जो इतना लिखा है ना, नो फर्दर ऑर्डर इज रिक्वायर्ड टू पास within a period of
I'm obliging.
that may be a possibility.
For hearing, item 4.
Lord, I came to do the case, but suddenly I'm not feeling well. I thought I'll not take adjournment and do the case. I'm having allergy problems since Friday. I'll not be able to do the case today.
Unwell. That this acting vice principal is now changed, or the same person is working as acting vice principal? Principal in charge.
My lord,
These
PIL is regarding.
affected villages. Okay,
this is-
sorry, that's another thing.
I
On the last occasion, we simply asked you that there
Yes,
some
now-
proper mechanism is there to
Yes.
control the flood is there.
Yes, my lord, the only mechanism for controlling, it's a natural calamity. Only mechanism is that the dam, the NEPCO authority will give advance warning before they
Yeah,
open the
On
area.
on the last occasion,
Radial
we
gate.
simply asked you that the Bihar NAPCO Limited is granted time to place on record the mechanism in vogue to prevent
Well,
the
it is-
situation of flood
Just,
of the kind which arose in. So
That's
that
14
mechanism is
14
there.
my lord, mechanism is there from very beginning. If your lordship will kindly. If your lordship can kindly
Just
turn
a-
to page four.
Just a minute, sir, just. Yes, Mr. Consul. If some mechanism is there to control any such situation in future, then what remains in this PIL then?
My lord,
If they're coming with this, that we have a proper mechanism and we'll follow this mechanism, then what remains?
And it's on record that we have followed. There is an inquiry by the district judge.
There is a dispute, sir.
Yes.
You are saying that we have followed
is
and
why
they are
your
disputing it. That's, without going into it, we'll simply give you a direction that in future, you'll adhere by this all, whatever the mechanism you are.
Lord, we have always adhered to that. And because they were disputing, the matter was referred for inquiry to District Judge Golaghat. He has submitted a report. If your lordship will kindly see report at page 207, your lordship
That
will
report,
see.
in that report, in fact, he blamed both of you.
No, both that we have filed an objection to that because he says that there was no negligence on the part of NEPCO. If your lordship will kindly see the report, which is report is wait. Report is on 6th page. Your lordship will see 207. 207.
Sir, we have gone through that on the last occasion. So regarding negligence of the NEPCO,
Yes.
as alleged by the writ petition, I found that the district administration, Golaghat, was alerted by NEPCO on so and so. said message was there that water will be released in the dam, water will reach so and so from the dam authority has been conveying the information of WhatsApp messages regarding so and so.
My lord.
District administration were acquired coming into situation onwards, but they did not make appropriate
That's
evacuated residents.
Yes.
As a result, flood condition deteriorated more. As water of the rivers was already in rising
Rising.
condition due to rain, excess water of the dam is caused so and so and so. Ultimately, he said, administration so and so, the NAPCO is not solely liable for flood.
My lord, that's what.
Not solely, but you are liable for
but
flood
how
along with
can
the
I be-
district administration.
My lord, may I just, that's why I will take your lordship through page 14 of the paper book, my lord,
Yes,
annexure B. Kindly see,
yes.
page 14 is, my lord, the
Page,
1/4, my lord. Page 14
yes.
of the PR. This is minute meeting of early warning and flood forecast held on 17/5/2018 at conference hall of deputy. Did you lordship get it?
Yes,
Annexure B. The DDMA meeting, this is District Disasters Management Authority, was held on 17/5/2008 at Conference Hall of the Deputy Commissioner's Office, Golaghat, under the chairmanship of Gaurav Bothra, IAS Deputy Commissioner Golaghat, for better coordination for early warning and flood forecast. The meeting was attended by SK Gogoi, ACS Additional Deputy Commissioner, DDMA Golaghat District Project Officer, so-and-so. Water Resources, Fire Emergency Service, and head of the plant of Doyang Hydroelectric Project, NEPCO, along with 2 officials from DHEP and NEPCO Wokha, Nagaland. The Deputy Commissioner Golaghat, in his welcome address, explained the relevance of meeting and saying that early warning and awareness is required at the downstream area as a part of flood preparedness for effective response and effort to minimize the loss of life and property. The Additional Deputy Commissioner DDMA Golaghat highlighted the necessity of early and effective warning, sharing information and coordination among all the stakeholders. Head of the plant of NEPCO DEP said that, like previous years, the NEPCO would issue circular regarding opening of radial gate of Doyang Dam for releasing excess water. Further, disseminating warning to all concerns and especially community at the downstream to avoid swimming and bathing during the release of excess water. The meeting focused mainly on early and effective warning regarding the rise of water level, release of excess water from the project. Emphasis was given on sharing information with the district administration and all concerned stakeholders, ensuring better coordination among them for forecast, early warning and response during emergency. The decision was taken in the meeting as the Golaghat District Administration as well as the NEPCO Authority would share their important contact details and email ID for regular communication. NEPCO Authority would share data regarding rainfall, water level. Awareness and early warning activity would be done at the downstream area before release of water by the NEPCO. DDMA Golaghat would conduct awareness meeting at vulnerable villages in coordination with BDO so-and-so. Then 5th, the NEPCO Authority shall inform the DDMA and concerned stakeholders regarding release of excess water in advance before reaching the spilling level. Now, your lordship will kindly come to page 92. I'll show all the WhatsApps that has been sent and its admitted position, 92. But still, your lordship sent it to the district judge, page 92, my lord. Kindly see the WhatsApp messages. The screenshot was typed and placed here. This is 21st July. We opened the radial gate on 27th July, my lord. This is 21st July. This is by my lord Ronnie Rajkumar from DDMA. Sir, madam, water level of Brahmaputra so-and-so following the so-and-so Dhansri. These are the details given on 21st July. Which says RWL of Doyang Reservoir as on 21/7 is 320 RLW is reservoir water level, my lord. Once it reaches to 324, we'll have to release the water. Then they inform us that, okay, please inform when you release. Then the next page, your lordship will see page 93. Again, the first one is from DDMA. Then we are writing RWL of Doyang Reservoir is as on 22/7 is EL 320.440 meter. The reply is, thank you. I will sure you will issue circular before release of excess water. This was on 22nd, my lord. The next page, if your lordship will kindly see. No, just below that, 23rd of July. Again, we are sharing. They asked any update. We said RWL of Doyang Reservoir as on 24/7 is 320. Then again on 24th July, my lord, your lordship will see. So this way we have been informing, and on 25th at page 95, your lordship will see. Page 95. This is just before, 2 days before opening of the radial gate. RWL of Doyang Reservoir is as on 25/7/2018 EL 321. We will be issuing circular tomorrow. But on the same day, we issued circular. Your lordship will see at page 96. Page 96. This is circular, my lord, dated 25/7/2018. This is for general information of all concerned that the water level of Doyang Reservoir is rising during the past few days to rainfall in catchment area. Reservoir water level at 16 hours on so-and-so days. EL is elevation level, my lord. 321. Doyang Reservoir operates by the authority of Doyang Hydroelectric Plant, NEPCO, and is likely to be filled to up to spilling level of EL 324 if the present trend moves or trend of inflow continues. In case of increase of water beyond 324, the radial gate of the Doyang Dam shall be opened, releasing the excess water. During the operating of the gates, the excess inflow will spill over and will flow through Doyang River downstream Doyang powerhouse. All concerns are therefore requested to be careful and stay away from Doyang Reservoir stream or the powerhouse, avoid bathing and swimming. And this, we had sent email to the Deputy Commissioner. We have also personally informed him on the telephone. Then after, your lordship will see on 26th, next page, 97. This is from the DDMA. They write about the Dhansering and the rainfall. Then we said, dear sir, if the trend of rising of water level increases, we may open the radial gate by Saturday or Sunday. Today, RLW is 322.3. This is on Thursday, my lord, 26. Then 27, if my lord will see. One interesting point at 98. The DDMA writes, can you please say EL stands for? So we say a division level. Then 27, RWL of Doyang Reservoir increased abruptly to EL 324 meter on 27/7, spilling of reservoir to start from today. So from 21st till 27, we have been issuing letters, exchanging, and that is what the district judge has stated, which your lordship has just seen at page 207. We are supposed to give them information as to early warning when we will release. We have done, and we have been doing since inception.
This incident took place on which date?
27th.
26th.
26th of?
27.
Not 27, not 26/7/2018.
26/7/2018.
7/2018. My lord. And this circular, which has been given on 25/7/2018, has been received by the authority district authority on 26th
So now.
by email.
Now, you just said, what happened, now this compensation has been paid to you, the agriculture.
That's from that side, from the government side, they want from us. The government is paying them.
That they already paid?
Government has paid some relief only. The relief
the
at the time of the
compensation
flood,
has been paid,
the relief we have received at the time of the flood, that much. No further compensation for the losses because
So what
water flows suddenly through
What
the-
is your prayer in the PAL petition? You just
Yes.
your prayer.
The three prayers.
That I am coming to the page 10, my lord.
Yes.
It is therefore prayed that your lordship should be pleased to admit this petition and call for the records issue rule calling upon the respondents to show cause as to why an appropriate redirection order shall not be issued, directing the respondents to regulate the water of the Doyang hydroelectric plant timely and also give early warning so that the activities could be done at the downstream areas before release of excess water to the NEPCO authority, and also to share the data regarding rainfall and water level, and further directed the respondent authorities to pay adequate compensation to the people affected by flood due to sudden release of water from the Doyang hydroelectric plants and upon such cause or causes that may be solved. That much. That is my prayer.
So the state government has conducted a survey regarding law.
My lord, that report is that, my lord, one report is at page 24, my lord.
24.
Page 24, my lord. That is one of the flash situation as on today, 3/8/24, 2018. My lord, they have given the list of the areas which are affected, my lord.
Whether they determine the compensation or what?
Now, regarding not the compensation, my lord, this is regarding the, my lord, damages caused to the
What about
entire
what
area.
about the compensation?
No, my
damages
lord, nothing, no, sir, no such, my lord, the report has been prepared, my lord.
No such report has been prepared.
No, my lord.
Yes.
My lord.
Yes.
My lord, what happened, my lord? From these WhatsApp messages, what my lord, has my lord enclosed, my lord. It has come to me that, my lord, that on 26th they are saying that is on 26th, on the day on which they have released the water. They are saying that if the trend of rising of water level increases, we may open the radial gates by Saturday or Sunday. That is on Thursday, my lord. That is 26th is Thursday. And they are saying they will release the gate on water on 26th on Saturday or Sunday. But on the same day, they have released the water, my lord, on 26th. And my lord, the reason for releasing, waiting for till spilling level, my lord. I'm coming to that. Why they have waited till for releasing the water till the spilling level, my lord. The reason is that, my lord, for the slicing of the sediments of the, my lord, reservoir.
Don't know. There's not.
Because, my lord, from the beginning of the this establishment of this dam, my lord, there was no such big, my lord, rainfall or, my lord, in this catchment area, and because of that, my lord, the sediments had lots of sediments deposited in that, my lord, the reservoir of the dam. And this time they got the chance, and they have waited till the elevation level. They could have released it before that also, some little slowly and slowly, but they have waited.
That is their mechanism.
Their mechanism, my lord, they, because of
What
this,
is
my
the
lord,
authority of the
my lord,
court? Just a minute, sir. What is
Lord.
the authority of the court of the petitioner to suggest them that release that at that level and not at that level? That is
my
their
lord, my
mechanism.
lord, they have.
We are not experts
My
in this, sir.
lordship,
We are not experts in
my lord, that is one mechanism for washing out the sediments, my lord. That is true, my lord. But I am also on that, my lord. They can do that. But my lord, before that, they should have given sufficient warning that this time because of heavy rain, we are going to do this. And this, for that, they have waited till, my lord, 26th and 27th, my lord. They are saying that we will release on 27th, my lord. As per their, my lord, state, my lord, WhatsApp messages, my lord. On 27th, my lord, Doyang River increases abruptly to 324 meter. On 27/7/2018, spilling of reservoir to start from today. When 27th, they are.
That distribution arose on the account of
27th, my lord, they have
this,
given that message.
rainfall.
And 26th,
Unexpected rainfall.
my lord, 26th, they have released the water, and 27th, they are giving message that they may release the water.
No. Unexpected rainfall.
And my lord, the circular also they, which, but that is true, my lord, there is unexpected rainfall. But the circulars they have given on 25th has been received by the authority on 26th. And 26th they have released. This is, my lord,
Yes.
beforehand warning, my lord, the information has not been given. That is my submission. my lord.
This PIL petition is filed by the petitioner highlighting an incident happened on 26/7/2018 and 27/7/2018 in Golad Ghat district in Assam, wherein on account of release of water in river Doyang by the NEPCO, several villages were affected on account of rising level of water. It is the allegation of the allegation of the petitioner that flood had occurred due to sudden release of water at Doyan Hydro Electric Project located in Wokha district of Nagaland, which is the Nagaland, and the same project is under the NEPCO on river Doyang. Full stop. This court, by the order dated 15/3/2022, after hearing the learned counsel for the parties, has issued a direction to the has appointed the district judge Golaghat to conduct an inquiry into the matter and submit a report before this court by passing the following order. This here at page 180, this the matter relates to from here. Matter relates to this pencil to pencil. 180. Pursuant to that, the district judge Golaghat has submitted its report before this court on 20th of October, submitted its report dated 20th of October 2022 with the following conclusion. This page number 207, after considering so and so and up to this 2018. Not only 2018 revealed. Full stop. And it consider appearing for the petitioner has submitted that as a matter of fact, there was a lack of coordination between the NEPCO authorities as well as the state authorities. And on account of that, the prior information for release of water from the Doyang River has not been furnished to the district authorities, and on account of that, the affected people from the concerned villages could not be evacuated or warned in time. And on account of that, heavy loss has been caused to the property of the villagers of the said, of the villagers. Full stop. For contra, the net council appearing for the NEPCO has vehemently submitted that the NEPCO has informed the state authorities well in advance regarding the release of water after it reached a certain level. It is submitted that the district judge in its report also has clearly mentioned that there is no negligence on the part of the NEPCO. Full stop. It is contended that as a matter of fact, from time to time, meeting is convened between the a meeting is convened between the district administration and the NEPCO authorities,
As page 15, my lord.
and in which it is and in those meetings, it is the understanding has arrived that the NEPCO would inform the district authorities regarding the release of water well in advance. It is also submitted that the incident, unfortunate incident of 26/7/2018 and 27/7/2018 happened on account of unexpected heavy rainfall. Learned Council for the NEPCO has emphasized that a mechanism is well in place to prevent the situation of flood. And the NEPCO is bound to follow the said mechanism in its full letter and spirit in future. Full stop. Learned Council appearing for the respondent state has also submitted that the state and the NEPCO in the state and the NEPCO authorities are in tandem and will follow the protocol regarding the release of water. It is also stated by the learned counsel for the state that the unfortunate incident of flood situation on 26/7 and 27/7/2018 happened on account of unexpected heavy rainfall. Stop. Having heard the learned counsel for the parties and after going through the material available on record, we are of the view that the state administration as well as the NEPCO authorities are required to function function with a better coordination to prevent a flood-like situation which happened unfortunately in the last week of the July 2018. Full stop. We hope and trust that the state administration and the NEPCO authorities shall take effective steps for preventing any such situation in future. With these observations, this PIL petition is disposed of.
My lord, I'm making a prayer in advance. Tomorrow the Nagaland case is there.
Yeah.
Tomorrow one Nagaland case is there. I will circulate this thing. I'll not be able to.
Which matter?
My lord, it will be tomorrow.
Tomorrow.
It is a Nagaland matter where Advocate General appeared that your lordship has fixed tomorrow.
Yes,
But-
will not be able to come.
Will not be able to come.
Will
I'll-
you
Yes,
inform him in
Yes,
advance.
my lord. Will
Much good. Item 5 and 6.
May it please, your lordship. So this matter may be. My lord, this matter may be taken up after some time. My senior Mr. K. N. Chaudhary
How
will
much
act on
time,
check number.
how much time after some time?
Yes.
Tomorrow or day
But
after
he is in
tomorrow
lakhs,
or
my lord.
after summer
He's
vacation?
on lakhs, my lord. Just after completion of that matter, he will come back.
After summer vacation.
My lord, we are going to retire, my lord.
Yeah,
The appellants are going to be retired. Some two has already retired now, two is surviving, my lord.
24 June.
Lord, on the earlier occasion also adjournment was prayed for and we have not objected, my lord.
yeah.
24 June.
Next week, any date, my lord.
24th of June.
March.
Much. Apply.
Item 12.
This is a PIL of 22, and this honorable court issued notice to all the respondents. They have filed their responses. Basically, the prayer at my lord, page 16 of the petition, the whole matter was, my lord, mismanagement of, my lord, some amount of money in a college, my lord, particular college. So we basically wanted investigation. Till then, my lord, no investigation was made, no inquiry was done. Now, during the pendency, my lord, the government directed for a inquiry, and the report has come at page 107. And which, my lord, in a way, proved our apprehensions right, that there were mismanagement. Page 107 to 10111. Lordship may. Huh? This is the letter by the inquiry officer to the Director of Higher Education, my lord, page 107. And the report of the inquiry was enclosed there. And my lord, lordship may go to the last
Page number
110. Last page. Here the conclusion, your lordship will see.
110.
Lordship. 110. There was a conclusion given from the above facts. It is clear that so-and-so retired in charge principal was not at the helm of affairs during the period where alleged non-remittance from 70% of tuition fees to the government exchequer occurs. Then principal, so-and-so retired in charge principal for the period of so-and-so to so-and-so had spent all the tuition fees as per records made available. And for the period 2018-19, the amount was not deposited by the principal in charge so-and-so. So action may be taken to recover the tuition fees from the college authority and remitted to the account, my lord. So in this view of the fact that the inquiry has been made, we initially demanded SIT, my lord. I was engaged, my lord, during the pendency in this case. I think, my lord, that is not necessary. And by lordship may close the matter. Till now, this is a report of 2023. To our instruction, my lord, no action has been taken till date on the basis of the report.
This was
He will be
done,
better placed.
this was done as per lordship's direction, lordship. This inquiry was done as per lordship's direction. During the pendency of the PI, my lordship directed us to cause an inquiry, lordship. And on the basic, as per lordship's direction, we have done the inquiry, lordship. As because if PI is pending, lordship, we are not taking any action.
We are not taking action.
So with that, my lord, lordship may close that matter. Let them take action.
Otherwise, lordship, the basic grievance is against the lordship.
When this court has issued direction for
Lordship, it's a verbal order by earlier honorable my lord chief justice as verbal.
Date.
No, it was not in the lordship, it a verbal direction.
Oral order.
Oral direction by the honorable chief justice of the lead and chief justice.
Also, if lordship is, goes with mega, even if I am submitting one thing, lordship, even if this petition is not entire, maintainable, because entire facts and circumstance document annexed here against the respondent number 6, his, her appointment.
Respondent number 6 is now retired.
Retired, that is my appointment is still here, that cannot be.
You continued your term and now retired?
Yes, he is continuing, but Lordship, the allegation which was Lordship against the SO number 6 was not proved, Lordship. She was not at that point of time.
In any case, he has retired,
This is
my
what
lord.
the inquiry said.
Lordship.
This is what-
In any case, he has retired, my lord.
This writ petition is filed by the petitioner in public interest, essentially raising a grievance regarding the appointment of the respondent number 6 as principal in charge of the college. Which college?
This is my lord,
RK Nagar College, Karimganj, Lord.
RK Nagar College, Karimganj.
RK Nagar College, Karimganj.
Ramakrishna Nagar.
RK Nagar College, Karimganj.
Yeah.
Full stop. Allegations regarding misappropriation of some fund has also been leveled against the respondent number 6 as well as the other authorities. Full stop. It appears that during the pendency of the writ appeal, this writ petition, the state government has conducted an inquiry through the financial advisor, through the auditor of the DHE,
Director of Higher Education, Lordship.
through the auditor of Director Higher Secondary Education, the Higher Education, and the financial advisor to the Director of Higher Education. Full stop. In the said inquiry, it is concluded that the respondent number 6 retired in charge principal was not at the helm of affairs during the period when the alleged irregularities has been committed. It is stated in the, it is also concluded that the then principal in charge, the principals in charge were responsible for the misappropriation of money. Full stop. In the inquiry report, a recommendation is made to take action against those principals in charge who were found to be involved in misappropriation of money. Full stop. Learned concept for the petitioner has submitted that since the inquiry is already conducted by the authorities concerned, he is satisfied with the same. However, has submitted that as the on the said inquiry report, the said inquiry report is of the year 2023, but the state authorities till date has not acted as per the recommendations of the inquiry report. Full stop. It is submitted that therefore a direction be issued to the respondents to take action on the recommendations given in the inquiry report. Full stop. Learned concept of the state has submitted that since this PIL petition is pending, no action has been taken on the recommendations given in the inquiry report. Stop. Taking into consideration the above facts and circumstances of the case, we are of the view that no further order is required to be passed in this PIL petition. However, it is expected that the state government shall take appropriate action on the recommendations made in the inquiry report expeditiously, strictly in accordance with law.
Obliged, lords.
With these observations, this PIL petition is disposed of.
Item number 7.
May it please your lordship. This writ appeal has been restored to the file pursuant to the order passed in the review petition, lordship. If I can take your lordship,
You please supply the review petition order.
I have already. The review order is dated 22/11/22. 22/11/22, lordship. Page 2, the order starts.
Page 2.
Facts are narrated, lord.
Yes.
So my lord, in view of that order passed in the review petition was clear that the private respondent did not meet the eligibility criteria that was called for by way of the notification dated 16/6/2012, which your lordship will find at page 39. Mandatory requirement and qualification. The candidate for the post of Anganwadi worker, helper, shall be a local woman residing in the concerned revenue village where the Anganwadi center is located. The candidate
While
for,
the learned single judge has refused to interfere in the matter.
my lord, the single judge's order is at page 70. Seventy-six is the operative. Page 74, lordship.
Yeah.
Findings at page 76.
Read.
If I can read, my lord, para 7, the respondent number
When
4.
you come to para 11.
Yes, my lord. Para 10 and 11. In the above conspectus, let us examine the impugned order dated 2/7/15 passed by the Director Social Welfare. A perusal of the aforesaid order would reveal that the same has been passed after taking the following factors into consideration. Lordship, serial number 2, contradictory certificate
Madam,
regarding
read
the,
all the inquiry report dated program officer,
yes, my lord, which talks about
the
the
inconsistent stand
stand
of
of
the
the
Gaon
Gaon Bura.
regarding
Regarding the residential status of the respondent number 5 with further statement of the local people that the residence of the respondent number 5 is Uttar Bogoriguri. Contradictory certificate regarding the residential status of the respondent 5 issued by the Gaubura, same Gaubura Lolit Mili. Certificate issued by the circle officer Majuli Revenue Circle dated 31/3/15 certifying that the respondent 5 to be a resident of Uttar Bogoriguri village. Further report by the CDPO dated 26/5/15 revealing that Uttar Bogoriguri Mini Anganwadi Center is located in the northern side of Bogoriguri and the residence of respondent 5 is located in the same area. This was wrong, my lord. That was substantiated by the affidavit filed by the government advocate.
earlier also they have submitted a report now affidavit in something they are saying contradictory to it.
My lord, in the affidavit filed by the learned government advocate in the review round, had clearly stated that both one part is located at Lower Yokaibua Gaon, a part of Bogoriguri village, and North Bogoriguri is located, situated at Bengena Kolia Miri Gaon. They are in different revenue village, Lordship. So, my lord, in view of that affidavit filed, the review was allowed. And there is a self-declaration of the,
There was some selection process.
yes, my lord, advertisement was issued. Pursuant to that,
In order of merit, what is the standing of your client?
merit that was required was that class 8 pass, which my,
Was there a select list?
no, my lord.
What makes us conclude that interfering with the appointment of respondent number 5 will lead to your appointment? What is the principle?
My lord, a person cannot be allowed to take advantage of his own wrong.
Correct.
Yes,
But
my
even if we set aside the appointment of respondent number 5, they may not appoint you. Why should they appoint you?
Yes, my lord, that is there.
No answer to that.
But my lord, somebody is sick.
What is the, her spending is?
There were two pending.
But since now the selection took place in the year 2013, 12 years have passed.
My lord, but
You might be overaged by this time.
that part I'll take instruction, but
12 years old is. Maybe you're correct that she is not the resident of that area, but now after 12 years, it would be very hard.
no, my lord, but the law is that one
That's
cannot
right.
take advantage
We are
of his own
completely with you on law,
wrong. Yes, my lord.
but looking to this fact that 12 years have passed now.
And there was in one way, a fraud had been committed, and fraud unravels everything.
Not fraud, but yes, there are some irregularity, but what is the yes, what do you want to say?
There is no
There is
illegality in the
nothing
order.
which cannot go any up.
There is no illegality in the order passed on a
The
single.
order pass, you are not the resident, this is the prime condition, this is
No,
the
my lord.
principal requirement that it should be the
I am the-
resident
I
of
am
that
the
area,
resident.
you are not resident of that area.
I am the resident of the area, my lord. The residence certificate issued in the 2023 also.
Absolutely nothing. Now, after this, in the review order, the division bench has threadbare everything.
My lord, review petition, my lord, we did not receive the notice in the review petition. So, my lord, we cannot.
Should have
place our case.
filed a review for that.
My lord, so
But
far the,
receive the notice.
my lord, so far the impugn judgment is concerned, my lord, there is no illegality as such, my lord, because, my lord, everything has been considered by the Lana single judge, my lord. And the certificates issued by the Gambura, my lord, it is inconsistent.
Leave it. This writ appeal is filed by the appellant being included with the order dated 192, judgment dated 192,020 was passed by the Lalit single judge in writ petition number 1900/2016, which was whereby the writ petition filed by the appellant has been dismissed. Full stop. The matter is in relation to the appointment of the Anganwadi worker in Uttar Guri Mini Anganwadi Center took place way back in the year 2013. Full stop. The appellant is claiming that the respondent number 5, who was selected for the post of Anganwadi worker of the aforesaid Anganwadi Center, is not the resident of who was not the resident of the village wherein the Anganwadi Center is situated. It is asserted that in the advertisement as well as the selection criteria, it is specifically mentioned that the person engaged as a Anganwadi worker should be resident of that village only where the center is situated. Full stop. It is contended by the it was contended by the appellant before the learned single judge that the respondent number 5 is not the resident of the village where the center is situated. Therefore, her appointment is liable to be set aside. The learned single judge, after considering the report, after considering the order dated 2/7/2015 passed by the Director of Social Welfare, whereby the claim whereby the claim of the appellant was rejected, has come to a conclusion that the factors considered by the Director of Social Welfare are relevant and germane to the issue and therefore are not liable to be interfered with. Full stop. Learned single judge has further observed that it is only decision making process which a writ court is entitled to examine and not the ultimate decision of the not the ultimate decision. Full stop. Learned counsel for the appellant has vehemently submitted that earlier the special appeal writ appeal number so and so challenging the impugned judgment passed by the learned single judge was allowed on which date it was allowed?
It was
On
dismissed.
21/12/2021,
It was dismissed, my lord.
relying on the statement of the learned counsel for the state that
Writ appeal was dismissed.
Writ appeal was dismissed.
dismissed, relying on the statement of the learned counsel for the state that the respondent number 5, that the village of the respondent number 5 and the village where the Anganwadi center is situated are falling within the same revenue village. Full stop. It is submitted that later on in a review petition, the order dated 21/12/2021 passed in writ appeal number 104/2022 passed in this writ appeal. This is writ appeal number 293
of
Why
21.
it is.
No, same.
This was reviewed, Lordship.
Same writ appeal.
It has been restored to the file.
That's a review, sorry. What I'm looking, can you cut? Review petition number 104/2022. The order dated 21/12/2021 was recalled and the writ petition, writ appeal is restored for hearing. Full stop. Hearing, it is submitted that in the review order, the division bench of this court has come to the conclusion that the respondent number 5 is the village of the respondent number 5 and the village where the Anganwadi center is situated are falling in different revenue villages. Full stop. And it counsel For the appellant has therefore submitted that it is proved that the respondent number 5 is not the resident of the same village where the center is situated, and in such circumstances her appointment on the post of Anganwadi worker is liable to be set aside. Full stop. Learned counsel appearing for the respondent state as well as the private respondent has opposed the writ appeal. Full stop. Having heard the learned counsel for the appellant and after going through the material available on record, particularly taking into consideration the fact that the selection for the post of Anganwadi worker on the concerned center took place in the year 2013, and 12 years have passed. 11 years have passed till 11 years have passed. Therefore, in such circumstances, therefore, in the peculiar facts and circumstances of the case, we are not inclined to interfere in the impugned order. Hence, this writ appeal is dismissed.
Item 13 and 14.
May I please, Lordship. There is a connecting matter, Lordship. I am in the item number 14, Lordship. Lordship, I am paying for accommodation for today only, Lordship. And he has
What
also
about item number
objection-
13?
Referred by the state lordship, same is similar issue.
Lordship may,
What do you want?
Lordship may fix a short date as since the respondent is.
Now it will go after this summer vacation.
Lordship, can it be a little shorter within this month?
This after the summer.
Item 17.
This is a writ petition prepared by the department against the order filed by Leonard. She said thereby the charge sheet was quashed and then it's listed. Respondent is appearing, but
Who is appearing for the respondent?
Devalina Chaudhary.
Name is
not been shown.
Today morning,
Name is not shown.
Lordship,
Name not shown in the contract.
Lordship telephoned me that
Also name shown. Name and name.
So what do you inform me?
she said that she will do this. She asked me whether you are taking time. No, I'll drink this. She said that she will be present at the court.
You have returned late in the evening last night.
Yes, Lord.
Maybe she
taken
is
up-
aware of that.
But you are ready of the.
No, in this case, Lordship, earlier I prepared some notes that is available in my record.
Okay. But what happened? What was the charge against him?
Lordship, charge was that while he was Commissioner for Appeals, he allowed on high value.
How can it be? It is a judicial matter.
Lordship, I will satisfy Lordship.
Judicial matter, in one day you have passed this order. So tomorrow if a Leonard single judge decide any petition and we decide it in appeal today itself.
Probably
What's the
we cannot-
yesterday, if any judgment is there and today appeal comes to us, we
Lordship-
decide it, then
Lordship, pleased to see the charge sheet.
quasi judicial.
Lordship will be surprised to see the charge sheet also. Lordship.
Yes.
Lordship, then because my learned point is not there, maybe taken up after.
Some other issue.
Item 24.
Lordships, affidavit has been filed by respondent number 1 yesterday evening. I would request if some time can be given to me to file a response to it in a week's time.
You're for the state.
No, I'm for the appellant, the association.
As an appellant association.
Yes.
Let me consider the appellant face sometime here by counter to the additional affidavit filed on behalf of the respondent, filed on behalf of the respondent on 10th of June 2024. Template for a granted list after summer vacation.
May I request a specific date, any date?
Summer vacation,
The vacation.
take the date from registry, it's too early.
I will.
After vacation.
Item 25.
May it please your lordship, lordship, today we pay for accommodation lordship. And I have informed the sir also. lordship.
I know, my lord, but there was some urgency in this case. I know there is some difficulty. Urgency in this case, my lord. I know there is some difficulty other side. We were the principal of the college. And thereafter, as an OSD, we have taken by the government in 2021. Now that's what was put to challenge. We said that you can't do it as an OSD. It's like a deputation. And neither you cannot transfer under the rules. So the learned single passed in our favor. State went for an appeal, but there was no interim order when we moved the matter. So I was faced under suspension. After the order passed by this court, by the single bench, the suspension was revoked. And I joined. After joining the service, the state has preferred appeal. I have seen, my learned friend was there. I think a bit of the honorable chief is a bit annoyed because you didn't join. Why you didn't join the service at that time? Because there was no interim order.
But
There was no interim order. So this order was stayed. So meaning thereby I am an OSD. Now I have served in OSD. I am serving as an OSD as per the order passed by the government. So now, my lord.
So you are interested in serving as a OSD or?
OSD.
No, you are interested in serving as a OSD or you want to this?
No, today I am serving as OSD as per the orders of the government. Now that's the whole problem. I am going to retire. Now, as per the provision of law.
When?
Retirement? 2 years, 1 or 2 years. But the purpose which I have been brought, that purpose is not being utilized. So, my lord, any date which is convenient.
Just at the start of the summer vacation.
Whichever is convenient. Only after.
18 July.
18th July. 18th July.
18. I am deeply obliged.